I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always by my appealing co-host, Brett.
Oh, thank you, Alice. I always knew that you loved me. It's nice to be reassured by your words that are totally about me and not the subject of today's podcast.
100% about the subject, nothing to do with you. Sorry, I just love puns. Thank you guys for, letting me do my punnerific introductions. But today is the appealing appellate process. And it actually does describe Brett very well. For those of you who know and love our amazing trial lawyer, Brett, you may also know that he is an incredible appellate lawyer. I always leaned on him for all of my appeals because, as we're going to talk about, appeals, especially of a jury criminal conviction, if it's a direct appeal, is based on the whole record. And if you've ever read the transcript of an entire trial, it is lengthy and it is a little boring sometimes. But this is what Brett specializes in. So you are appealing, Brett, and we are going to walk through the appellate process today with appealing Brett.
Well, thank you, Alice. I appreciate that. And this is a subject that comes up every now and then, but I feel like we're in an interesting time in true crime. It feels like we've had a bunch of trials recently over the last few years, and now they're moving into this appellate phase, and people are starting to ask questions, whether it's Murdaugh, which we saw some stuff bubble up with at the beginning of last year, but I think also tells you how long this process takes, because that trial now was 2 babies ago for Alice, and that appeal is still ongoing. And then obviously we have the Delphi case, which will be moving into its appellate phase, and is a case people follow very closely and are very interested in the appeal in that case, because there are people who think there may actually be viable issues. So we wanted to talk about sort of the process, how it goes, so as you're following this, you're not surprised, and it is something that you can understand. As Alice said, I've done a lot of appeals in my life, so hopefully I can give you guys a little bit of an insight. But Alice, she sells herself short. She is also an excellent brief writer. Did you ever do an appellate oral argument?
I did. And also, my second clerkship was in an appeals court. And really, it was seeing the trial and the appeals. Look, the appeals process is awesome. It's actually much calmer than trial. But I think I thrive in the craziness of trials. And I did a lot more of that when I was at DOJ, when I did not prosecuting.
Right. The thing about it is most people's conceptions of the law and lawyers is very narrow. It's based essentially on Law and Order, right? Or Matlock or Perry Mason. So they think of there are lawyers who go to court and they're in trial, and that's what they do. And that's the vision most people have of lawyers. But in fact, there are so many different kinds of lawyers and different kinds of law and different aspects of the law. And a lot of times the people who do trial work, for instance, don't do appellate work. And we're going to talk about that a little bit as we get into this. So when you think of an appeal, appeals, much like trials, are your right. So everyone has a right to appeal. So just like if you're charged with a crime, you have a right to trial. If you are convicted, you have a right to what is called a direct appeal or an initial appeal.
Can we slice and dice it? Because this is what lawyers do. Specifically, you have a right to appeal only in criminal cases. So there's not necessarily a right to appeals in civil cases. I think this is important because a lot of criminal cases have civil aspects to them. So there's the typical civil cases where it's just, like a breach of contract. Like you said you were going to deliver widgets, you didn't deliver widgets. That's a pure civil case. But as we've seen in wrongful death suits, that's technically a civil suit, but the premise is some sort of probably criminal act underlying it. So note that there is a right to appeal in the criminal context, not in the civil context. And the right lies with the criminal defendant, not with the prosecution. So while the criminal defendant can always appeal a guilty conviction, the government, which brings the prosecution in the first place, doesn't have a right to appeal a not guilty verdict. So this is important, I think, to parse out because of, especially when we start talking about imbalance of resources and, whether things are fair or not to the criminal defendant. Note that this is where the rights lie.
And that's a really good point. We focus so much on criminal law. Sometimes I forget civil law exists, but Alice is right. You have rights in civil court, obviously, but they're very different from the rights you have in criminal court. And rights in civil court can often be bounded by statutes, for instance. And so when you have a right to do something versus when you have to show a reason, some sort of justification, right? When you have to prove to an appellate court, like, hey, this issue is actually worth your time. You might have to do that in civil court. Whereas in criminal court, the defendant, as Alice says, has a right to appeal, and an appellate court will consider that. They may not give it much time. The opinion they write might be pretty short, but they will consider it. Just to step back, since Alice mentioned the state. So prosecutors can appeal certain things, interlocutory appeals, which is really the first stage of appeals, because they occur in the middle of trial or even before trial begins. So interlocutory appeals, think of the Richard Allen case. His lawyers are removed. He files a mandamus petition to the Supreme Court. Mandamus basically means in Latin, we command. So the point is, you want the Supreme Court to command the lower court to do something that you feel they are obligated to do. So they filed that. It was considered, and the court did issue the mandamus commanding the lower court to reinstate the prior attorney. So you can do that. Another instance in which you might be able to appeal if you're the government. Say Richard Allen's defense attorneys had moved, which they did, sort of. So they moved to suppress the evidence for various reasons, right? Like say they had gotten that bullet suppressed, and the prosecution felt like without the bullet, our case is going to be very difficult to win. The prosecution can file an interlocutory appeal and make the argument to the court, look, you should hear this now because we're the prosecution. As Alice said, we can't appeal a not guilty verdict. So there's no relief for us after trial. This is a critical piece of evidence. This is a critical decision. Pause the case, decide this issue, and send it back. That actually happens not infrequently. In fact, I think in one of Baldwin, maybe, I forget which one of them won in Indiana a significant suppression issue at trial. And the prosecution actually did exactly this. They had an interlocutory appeal. It went up, and that suppression was reversed, and the evidence came in, and he ended up losing that trial. And a lot of times for defense attorneys, suppression is where it's at. Like if they win the suppression motion, they win the case. If they lose the suppression motion, they're really looking for a deal. So for the prosecution, it can be very important if they win that motion to try and get it overturned in some sort of interlocutory appeal. But as I said, that actually happens before the trial even occurs.
So think of it this way, because I know these words may not be familiar to the layperson who hasn't been to law school. So interlocutory, just think the game is still going on, right? By game, I mean, if you're playing a board game, you haven't reached the end of it. You're still going to come back to the actual trial, the actual prosecution that's before you. You're kind of saying, wait, we need a ref on this issue.
It's like
that's
instant replay.
Instant replay. Yeah, basically like that. But the phases of trial of the prosecution, whereas the direct appeal, the case has reached finality and you've had the jury, if you went to trial with a conviction and then it's finished, there's sentencing, it's finished at the trial phase. There's no more things to do within the case at the trial phase. So think of it on those two things. They have very different processes and they're also very different reasons for why you seek interlocutory versus appeal of a final judgment.
And the structure here is important too, in case you're not aware of how this works. Typically, in the federal government and in most states, of course, every state can be different, there are three levels. There's the trial court, there's the intermediate appellate court. Sometimes that appellate court is actually divided into civil and criminal. So they're experts in that area of the law. Not always, but sometimes. And then typically there's a Supreme Court. Usually the appeal to the intermediate court, as we've been talking about, after a trial, after a conviction, is as of right. If you file a motion or a notice of appeal, you're getting an appeal. But usually, though not always, the Supreme Court has discretion over what issues they will hear. Think of the United States Supreme Court. The United States Supreme Court grants writs of certiorari every year. They get, I don't know how many, but they get a lot.
Thousands.
Yeah,
tens of
petitions.
Thousands, and they grant 75, something like 70 or 80 cases. And
those cases can be granted in a couple different ways. One is they can be decided on the papers, which is basically both sides file briefs. They submit them to the court. The court, which is usually a multi-member body, considers those. They can order oral argument and have the advocates come to the court. They will ask questions of the lawyers. The lawyers will answer those questions as best they can, and then the court will decide that way. The United States Supreme Court does decide a lot of cases. Typically, the smaller ones are the ones that are sort of summary reversals, that kind of thing. They do a lot of those without oral argument. They're a very oral argument heavy court. Typically, if they're going to decide something that's really important, they'll have oral argument. But most courts are not like that, even Supreme Courts. So state Supreme Courts, for instance, may very rarely grant oral argument. And there's an argument really in the courts and in the law about whether or not there should be more oral arguments, whether or not that should happen more often, whether the court should come together. Personally, I think there should be. I think oral argument is very crystallizing for the judges, and I think can really explain some of the issues and get down to brass tacks. Because you can write anything you want, right? I mean, you can write anything you want, send it off in a brief. Whenever oral argument is ordered, you're always like, oh, shoot, what did I say? Because now I have to defend it. Now I have to get up and explain why I said this thing, right? So that's something else to consider.
That's a really good kind of sidebar as to whether we should have more oral arguments. I generally agree there should be more oral arguments, but I'll say this. It's easier to write a good brief, but when you reach the oral argument for any case, you really begin to see good lawyers versus bad lawyers. And this is what I mean, is you have to truly understand your case. And those of us who do appellate law have seen and sat through really painful oral arguments where you can tell the attorney just doesn't know the depth of their case. They know maybe the issues in the brief because they could write it and someone could help them edit. They could research it. It's all within their control. When you're standing there and you have, 20, 30, 45 minutes to talk to the judges, what the judges want is not a recitation of your brief. What they want to do is to have you help them write the opinion. And what that means is they're probably not going to just adopt one side versus the other, right? It's not going to be like, all right, we're going to rubber stamp petitioner's brief. That's not typically what happens. And so what they do is they pose different hypotheticals and they want you to push basically your theory as far as it will go, because remember, their opinion isn't going to just have ramifications on your direct case at the trial level. Other courts within its jurisdiction, the trial courts that abide by that appellate court, have to follow it and apply it. And so because it has these broader ramifications, what the judges typically want to do at oral argument is to see how far your theory will go, what will happen if they adopt your theory, and then get you to concede certain things. And if you do concede the wrong things at oral argument, you can concede away your case. And that's the end of your case. So that's why, yes, if we have good attorneys, I'm definitely for oral argument, but it begins to kind of show the divide in the quality of lawyers, because if you have the wrong lawyer arguing a case, they, obviously the court can do whatever they want and ignore what the appellate advocate says ultimately, but you can make a lot of missteps because you have to think off the cuff and you have to know the chess moves, basically, of what it means for the court to take whatever number of positions it must take in order to decide in your favor.
And because it has so many ramifications, it's also much more removed from a lot of the drama in true crime, right? Like all that stuff. Like trials, you feel the effect of news coverage and the media and the way the lawyers are playing to the camera and how everybody's trying to influence the jury and all this other stuff. Appellate lawyers, appellate judges are very removed, and they like to be removed. They view themselves as sort of these
academics.
Academics, yeah, exactly. Philosopher kings, like up in their towers, handing down the law like Moses on Sinai or something. So in a very real way, the higher you get in the appellate process, the less your case matters, the less you matter, the less this is really about you. This is about sort of bigger picture things, which obviously can be very important for you. But, you'll see instances where people win the issue and lose the case, where the court says, you're right on this issue. Absolutely. That was a violation of rights, and we're never going to let that happen to anybody again. But guess what? Because of the standard and the fact that we find it's harmless in your case, you're still going to be executed. But good job ensuring that the next guy won't suffer the same fate as you. You see that happen in appellate cases.
And another sign that appellate cases have broader ramifications, and it's not just about your case, are something that you may have heard of before called amicus briefs, right? Friend of the court briefs. The reason you'll see, let's say, videos in the courtroom is an issue. You may see a bunch of public defenders or maybe defense people who want their, dramatics to be on TV file a bunch of briefs that it's not their case. It's not their client. But why are they filing these friend of the court briefs? It's because the legal issue that is being decided may have ramifications on what agenda or policy that they want to push for. And so that's another way to know that it's more than just your case. And the reason I say this is important is when we get really honed in on one case, the Delphi case, or, whatever trial you're very invested in, you think every single thing that happens at the trial level has to do with your case. And it does, because that is before the trial court. That is the evidence in that court. But when you get removed from the trial level, no longer is this just the Delphi appeal. This is an Indiana appeal that will have ramifications on all Indiana cases. Right. And so you can't look at it so myopically. And you have to also read the opinion, recognizing that it's not just about Richard Allen, not just about Delphi.
And really good appellate lawyers understand that, and you'll see them do that. If you guys are familiar with the West Memphis 3 case, there's a DNA statute, and all the way back in 2010, 2011, it was like the first time it was ever used and how it was going to be applied. And their lawyers, when they went to the Arkansas Supreme Court, they said, hey, obviously this is important to our client, but what this is really important to is everybody else. What's really important is how we're going to apply the statute across the state of Arkansas to all these different cases. And that's what we need to think about. And oh, by the way, if we do it the way we should, we're going to win. And that's a very effective thing to do because you're already channeling into what the court is interested in. They don't care about your guy. They don't care about the great injustice. And you'll see this sometimes with defense attorneys, like trial level defense attorneys who do appellate work too. They'll get up there and they're so focused on their client and their case and the facts of the case. And the court is trying to ask them questions about the bigger picture. And they kept trying to bring it back to the facts of their case. And you're like, you're totally missing the point. And you see that happen a lot, which is why, one of the reasons, you do have right to counsel on a direct appeal. And oftentimes that counsel will not be the trial counsel. So in Delphi, for instance, there was a motion to appoint appellate counsel. And of course, I'll try to be respectful. All the crazy conspiracy people out there were like, oh, Judge Gold probably won't even grant this because she's evil and she's trying to railroad him. And it's like, of course she's going to grant it. It's pro forma. He gets appellate counsel. His 2 attorneys are not really qualified to do appellate work. He's going to get counsel. And of course, they were appointed and he has a right to that counsel at the appellate level.
By the way, the reason you have a right to counsel for the direct appeal is the Supreme Court said that the Sixth Amendment allows you to have counsel at all the critical stages of your criminal prosecution. So it's not just at trials. You can think about it this way. If you have a right to appeal, then that's clearly a critical stage because you have a right to it. Is it a meaningless right if you don't have a right to someone who can effectively advocate for you? Yes, right. And so that's kind of the reasoning behind it. That's why you also have a right to counsel for pretrial stuff. I think if you're like part of a lineup, right? Sentencing, right? You have right to counsel because those are critical stages in your criminal prosecution that have very substantive effects on your constitutional rights. So that's where the right comes from.
And we're going to talk about habeas appeals in a second. But interestingly, you do not have a right to counsel on habeas, on what's called collateral appeals, which is sort of later on when your main appeal has been decided and now you're attacking specific issues, particularly one of the biggest ones, ineffective assistance of counsel. We'll talk about that in a second. You actually do not have a right to a counsel at that point. And because you have a right to counsel on initial appeal, you do have a right to competent counsel, so you can attack that counsel's performance as well. Typically, you're not going to bring an ineffective assistance of counsel claim on initial appeal. Initial appeal is going to be what we call substantive. So really, initial appeal is when you see these kind of claims that you're actually innocent. There wasn't enough evidence to convict you. You
should have let in certain evidence. Shouldn't have let in certain evidence.
Right.
Shouldn't have let them know that I had a lot of rape convictions. That sort of thing.
Should have allowed for a defense. So in the Richard Allen case, one of the big issues is going to be this third-party culpability defense, the sum of the due did it defense, the odinist defense. They will appeal that. That'll be one of the issues. But one of the other things, they'll say there should have been some sort of directed verdict. There wasn't enough evidence, all that kind of stuff. We'll see all that. I'm sure the Franks motions will be discussed. And these appeals, these initial appeals, can be really long, particularly in state court. A lot of states have very liberal rules on how long your briefs can be. So you'll see briefs that are 150 pages and 25 issues. And Alice is shaking her head. They are
I'm saying that's so painful as like the attorney who has to respond to it.
And honestly, I don't think it's very effective. I think, this is all sort of inside baseball stuff, but I always think the sort of, and part of this is court's fault, right? Because courts have said that if you have the opportunity to raise an issue and you don't raise it, you've abandoned the issue. So what you end up having is, instead of having lawyers really focus on the main issues and really hammer on that, and maybe if something is developed later on, we can bring up this other issue. We're really going to go for these 3 issues. You just throw everything at the wall, right? You see that a lot. In federal court, thankfully, there's like a 15,000 word limit. So you got to get it within 15,000 words, which sounds like a lot. And it is a lot. Very rarely do I run up on that limitation. But occasionally you do see it, particularly in cases that are very complex and have a lot of different sort of, maybe like a really complex white collar case, financial fraud case, that kind of thing. You'll see that. I expect in the Richard Allen case, it'll probably be a pretty lengthy appeal. Now, I think if they're smart, they'll focus on the some other dude did it. That'll be issue number 1. And why do I say that? Not necessarily because I think it's strong or it should succeed, but because it is a constitutional issue, one that is debatable. And because it's a constitutional issue, you have these things called standards of review that come into play, and they're really important. So, for instance, an objection, hearsay, overruled. If you want to appeal that later on, you've preserved it because you objected. That is going to be an abuse of discretion standard or a clear error standard. You're going to have to show that the judge in that moment was so wrong that no reasonable jurist would agree with them, and that it was so prejudicial to you that you should get relief. That's pretty hard. That's a pretty high standard, right? But when it's a constitutional issue, usually it's de novo or some sort of mixed standard, of which de novo is part of it. De novo means we start over. So the judge made that ruling, good for the judge. You may make some arguments the judge made. You may make the arguments you made to the judge. But we as the Court of Appeals are going to look at this anew with no thumb on the scales in favor of what was decided down below. So, for instance, in the Delphi case, the some of the dude did it defense thing is sort of a weird quasi-mixed standard, because the courts have said that your right to present a complete defense is something that is reviewed de novo. But within that, there are these decisions, these evidentiary decisions made by the judge, and the courts have also said those judges are in the best position to make those decisions. So it's a little unclear exactly what that means, but they'll have a more favorable standard of review on that than they will in some of the other evidentiary decisions that were made about what to let in and what to leave out.
And we have some really good comments in the chat right now while we're recording live. One thing to note about these appeals, remember at the trial level, you have the right to a speedy trial. A lot of the complex cases, that's waived by the defense because they want more time to investigate the case. Appeals have no timeline. And so when we're talking about these 150-page appeals, that also cuts against you, because the 150-page appeal probably is backed up by thousands of pages of trial record as well. And the judges have to read through all of it, sift through all of it and whatnot. And unlike at the trial level, when you do have a right to speedy trial within, so many days you have to go to trial, there is not that on appeal. I mean, really nothing holds judges accountable. I guess if you're at the state level and you're elected, there's that. But generally appeals, especially lengthy, complex ones, can really last even years. And so that's something to keep in mind, because if you've been convicted and you're sentenced, typically you don't get to be out until your appeal is decided. There are exceptions to that, of course, even some exceptions that we know of now in the news. But typically you are serving your sentence interlocutorily appealed. Those need transcripts as well. So that is a huge bottleneck there. I don't know. I mean, if you want, a great profession right now that is very, very in need of more people, court transcription, I think for several years now has been kind of in crisis zone in most jurisdictions because of lack of certified court reporters.
Yeah, and that's an interesting question of what's going to happen with technology. I mean, would you want your life to depend on whether or not the AI got the transcript right, or would you prefer a human being to do it? You can decide that for yourself. And another thing that delays it in a lot of states is there's a time period after where the defense can move for a new trial. Depends on the state. It could be 30 days, 60 days, 90 days. In federal system, you have to file your appeal in 14 days. You got 14 days. Now, you don't have to file the brief. You literally just have to file a notice that says, hey, we're going to appeal. You have to do that in 14 days. And if you miss the 14 days, that can be the end of your appeal just right there. There's a lot of procedural stuff you have to do when you're doing this that can cut off your substantive rights. And that's the way it works. And so basically, at some point after the trial, and I could be wrong about this, but I don't even know that Richard Allen's people have filed a notice of appeal. The lawyers were appointed, or at least the order appointing attorneys has been made. I don't know that they've been selected. Certainly the transcripts are not done. That's going to take a while. At some point, the transcripts will be done, and then a briefing schedule will be set. And the first mover is always the defendant. They're going to ask for at least one extension. They may ask for 2 or 3. And appellate courts are very liberal in granting extensions for a couple reasons. Number one, they're really busy and they don't care when you get your brief done. You do it whenever you want. Now, the government, they are more strict on us to follow the deadlines. But as far as the defense attorney goes, it is rare. Usually, I can think of instances where after 5 continuances, a year of continuances, the court finally says, here's an additional 30 days. We're not going to grant any more continuances absent good cause. So even then, they may still grant a continuance, but they're kind of getting antsy about it. But that can take a very long time. Eventually, they're going to respond. It's going to be lengthy. The government's going to ask for more time. They're going to get it because the defense asked for time and got it, and because it's lengthy. And just years can pass as this whole process is unwinding. And then after the government finally files its brief, the defense is going to have an opportunity to file a reply brief. And guess what they're going to do? They're going to ask for more continuances. And it's going to roll on for a while. And I mentioned Murdaugh for a reason. Now, that one got delayed because, they had that whole trial level thing about whether or not the jury had been tampered with. That was decided in January of last year. It's hard to believe. I didn't realize it was then. We wrote our op-ed on Fox News, if you haven't read it, about 2024, everything that happened. That's when I remembered, oh yeah, that was in January.
I thought that was 2020. I was how
exactly.
is this a whole year away?
Right. But that happened in 2024. That was decided in 2024. Guess what? His appeal is still going. Right? I don't know that the briefs have been submitted. There certainly haven't been any oral arguments or anything like that. And that was a year ago. He was convicted almost 2 years ago. These things take a really long time to work their way through the system.
So you heard from the submissions by the attorneys why that's taking so long. So the continuances on both sides just to go through the record, to actually get the record, go through the record, come up with your arguments, write these briefs. But then when it gets to the judges, there's not that many judges. And each judge has really a handful of clerks to help them. And clerks are just novice attorneys. They're usually not attorneys who've been out for 10, 15 years. Usually you're doing a clerkship in your first couple of years out of law school. It's almost more of a training thing. Of course, you're helping the judge, but you have a judge and not that many judges. And if everyone has a right to appeal, you can imagine how many appeals there are that they're faced. And then on top of that, all the collateral appeals, all the interlocutory appeals, all the civil cases. Most appellate courts, certainly in the federal system, civil and criminal cases and bankruptcy cases all go to the same set of judges. And it depends, which appellate court you're in, but we're not talking about hundreds of appellate judges. We're talking about a dozen or so appellate judges, a couple dozen appellate judges. If that, those are a dozen is about, is the median number sort of. If you have, California has a larger population, there'll be, more appellate judges, but we're talking about a very small handful of judges. And appellate courts, is it every state the same? Appellate cases are not heard by just one appellate judge. So at the trial level, you have one district court judge, right? When you go to the appeals process, typically there's a panel of judges, and typically it's 3 judges. And you have different sittings throughout the year in all these cases that they're prepping for, getting to know the legal issues and getting to know the record of that case to be prepared to even decide on the papers or decide they want oral argument. So that's why there's so much going on. And then if you decide to have oral argument, you have to give the attorneys a heads up. You can't just have oral argument the next day. Usually you give them at least a month, if not a couple of months, to say, we set it for oral argument, find the time that works for everybody because everyone's busy. These attorneys might be in other cases. And then once you have the oral argument, then you've heard everything. The case is submitted, for your decision, for your consideration. Then you sit down and start the process of deciding what your position is, but then lobbying your position to the other appellate judges who are on your panel, because you need to get a majority for your side. That's why there's the majority opinion. And the majority opinion is 2 or more, in a 3-person panel. And so there's a lot of work, even on the back end, just for the judges to reach their ultimate opinion.
Yeah, I mean, if you're hoping for a decision in the Richard Allen appeal in 2025, temper expectations because that is highly unlikely. Honestly, if you're hoping for one in 2026, obviously by the end of 2026, we'll have the briefs of all the parties, I would expect. We might have had an oral argument, but it's going to take the court a while to make the decision unless it's a slam dunk. I mean, sometimes they can do it pretty quickly, but this is a murder trial with a lot of different issues that were extensively litigated in the pretrial. So it's going to take a while. And it's going to go a while. And so then either Richard Allen is going to win and be granted a new trial, or his appeal will be denied. But whatever happens, there's still another level, the Indiana Supreme Court. And what you would expect then, if he loses, he obviously will attempt to take that case to the Indiana Supreme Court, which I think is a court makes its own decisions about what cases it takes. Could be wrong about that. There are a few outlier states that still have mandatory appeals to the Supreme Court. I don't think Indiana is one of them, but he's going to attempt to go to the Indiana Supreme Court either way. Were his conviction to be overturned, the state will do the same thing. And then that process will roll on. And while it's being decided, he'll still be in prison either way. And so it'll roll along and take yet more time. And more time will pass, and eventually that decision will be made at the state Supreme Court. Once that happens, once the state makes its decision, the only appeal is to the United States Supreme Court. So it does not work. Some people are confused by this. We have a state system and a federal system, and the federal system has federal district courts and federal appeals courts and the United States Supreme Court. But in a direct appeal that goes through the Supreme Court, the only court that can overturn a state Supreme Court is the United States Supreme Court. So that appeal will go directly to the United States Supreme Court, who basically, no matter what happens in this case, will deny it. I would be very surprised if this ever ended up in the United States Supreme Court. And that would be the end of the substantive appeal, but it's not the end of appeals altogether.
Because of what we mentioned earlier, collateral appeals. Those typically come after you have exhausted all your direct appeals. So collateral, as the name may suggest, is not really about the substance of your conviction. It's all the ancillary things, and essentially you are challenging the legality of being held in prison. And this is abstract, but we will give you specific examples.
Yeah, and I think one thing that's important to remember, a collateral appeal, the issues that were decided on the direct appeal are precluded. So, or issues that are waived on the direct appeal. Issues you don't bring, you can't raise on collateral appeal. It has to be something different. And that's why it's usually ineffective assistance of counsel. So that's usually when this comes up, is you'll see the challenge to the counsel now, which is something that everybody pretty much agrees you can't bring on initial appeal, and you can do it in this collateral space. The other thing is changes in the law often. Like if the United States Supreme Court decided that, murder wasn't illegal anymore, then you'd get to challenge your conviction on the basis of, hey, what I was convicted of is no longer a crime. I need a collateral attack on my conviction.
Yeah, and a way to think about the ineffective assistance being brought in the collateral appeal, imagine that your direct appeal was like, they shouldn't have let in all my past convictions, my past criminal convictions. That was way too prejudicial. The jury heard all of it and what a bad guy I was. So they had their mind made up that I was guilty no matter what because of what I had done in the past. And let's say the attorney never objected to it. and they're like, look, it properly came in, etc., whatever. You could then attack and say, okay, I lost the substantive appeal, but I can say my attorney slept through all of trial, which, by the way, sleeping through trial is not necessarily ineffective. That is a popular thing to attack. But you can say my trial attorney did all these things that led to a very bad case for me, and they were so bad it was ineffective.
And if you're interested in effective assistance of counsel, we did an entire episode on it, on legal briefs, towards the beginning of
talked
legal
about
briefs.
falling asleep.
Yeah, we
and
talked
not
about
being ineffective
and various other things. Yeah, because you not only have to be a bad lawyer, it has to have had an effect. So if you slept through the case, but your guy's on camera doing it, well, you really shouldn't have done that, but it didn't matter for the case. So, and as Alex was saying, I mean, the substance is, like we were talking about in the Pablo Velez case, there's this whole question of the fact that the bullets were matched to another crime in the gun of another person. No reasonable jury. Imagine, this is the substantive argument. No reasonable jury could have convicted based on the fact that the bullets used in the crime were matched to a gun used by someone else who was also there. Okay, that's a pretty good substantive argument about why the jury's decision was bad. But in that case, the appellate court said, well, might be a good argument, but you didn't preserve it at the lower court. Didn't really raise it. Didn't give the trial court an opportunity to consider it. So therefore, we're not going to consider it on appeal. Well, that's when on habeas, you would say, this was a very powerful piece of evidence. It should have been submitted to the trial court and for the jury to consider, but my idiot lawyer didn't even raise it. And so since he didn't raise it, he was ineffective. And there's prejudice because this is such a powerful piece of information that it would have changed the jury's mind. You should grant me relief on habeas, and boom, I win. And so that's how it typically goes. If it's a state trial, it starts in state habeas. And he goes through basically the same process we've just mentioned. It starts in the court of conviction. So in this case, for instance, let's say it goes through substantive appeal and it fails. Go back to Judge Gould. Judge Gould would decide the initial state habeas question because the idea is she is the most familiar with the case. She is the most familiar with everything that happened. She is going to be in the best position to decide whether or not whatever arguments are made, number one, are ineffective, and number two, would have made a difference. In the Richard Allen case, there's always interesting questions about waiver, frankly, of a lot of stuff that happened because of how hard he fought to keep his attorneys. So there's at least some things that I think are absolutely waived you couldn't bring up. But everything that happened after that, everything that happened in trial, for instance, you might be able to do. There's no real ineffective assistance of counsel argument for him. I mean, his case is going to rise and fall on the some other dude did it. If he can't convince an appellate court that that issue poisoned his trial and he needs a new one, if he can't do that, he's going to lose and no habeas claim will ever succeed. So just know that. Once he loses that issue, it's over. But in sort of a prototypical case, you'd start there, then you go to the appellate court, then you go to the Supreme Court. Now, the difference is once you have exhausted your state habeas, you can bring a federal habeas claim in federal district court. But under AEDPA, the Anti-Terrorism Effective Death Penalty Act.
Everyone calls it AEDPA, AEDP.
AEDP.
Now I can't spell it.
Death Penalty Act, yeah. Under that, you have what's called a 2254. 2254 is a state habeas petition that goes to federal court. 2255 is a federal habeas petition, so you were convicted in federal court, and they're going straight to federal court. So the thing is, what the courts are instructed to do in federal court is whatever decision the state's made, unless it is absolutely unreasonable, it stands. So it's a very high bar once you get out of state habeas and into federal habeas to convince a federal court, man, the state courts were so bad, you should grant habeas. So really, very rarely are those granted. And at no point in any of this do you have the right to an attorney.
And for these habeas cases, you typically have, 1 year to bring
1
them?
year.
So it's not, you forever have this ability
From
to
the
bring these
triggering
habeas
event.
cases. From the triggering event, right. So there's always the actual innocence claims based on,
Newly discovered evidence.
So yeah, some recantation or something came out where you found out there was a Brady violation. They didn't turn over something, or they forced someone to testify against them and it was a lie. Something like that, the triggering event. But you can't sit on it indefinitely. You can't have found out that the testimony against you the prosecutor knew it was false, and you just sit on it until 366 days, you're out of luck. Even if it was a real issue that could have been granted, it is a statute of limitations issue, and that's by statute as well. That's just to keep some sort of efficiency within courts. If you just have these cases open indefinitely, there is never finality. And so the statute of limitations is a balance between what is fair. You have to not sit on your newfound information, but also balancing kind of the finality of these convictions, that these cases don't go on indefinitely for victims, purposes, for the court's efficiency, for the prosecutor's efficiency, having to go backwards 10 years on these cases. Oftentimes they're new attorneys that have to take these cases on. So that's kind of that's the appellate process. There you go.
And I think what Alice just said is worth at least spending 2 seconds on, because we get really invested in all these individual cases, right? And we're like, why can't they challenge this? And why can't they challenge that? And man, they should be able to go back to court and all this other stuff. But the reality of the situation is we have very few courts and a lot of crimes and a lot of criminal cases. And we just do not have the capacity to reconsider every case 1,000 times because somebody thinks it's unjust. And that may seem cold and cruel, but it is, because it's efficiency. There has to be some efficiency in the system, or you're never going to be able to do all this. So there are limitations that may seem harsh, but are absolutely necessary.
And with that efficiency, it's not just efficiency for the sake of efficiency. When you spend more time on these types of cases, it's the same judges, it's the same prosecutors' offices. You can't prosecute more cases, right? This is just the reality. There are way more crimes, way more violent crimes, way more like heinous crimes against humanity that are happening than are prosecuted because of resources. So when you have no end to these types of appeals, what you're doing is you are quite literally taking away the resources to go after that robbery. Maybe you don't have the resources to go after the robbery, to trace down that child pornographer, because those cases are very investigative intensive. And so that's the purpose of the efficiency. It's not just for the sake of so we can go home and drink beers. It's because there are limited resources, and you as a society have to decide, are we going to indefinitely just do circles on these appeals over here when we already have a conviction and the record is very clearly supporting that conviction? Or do we allow some number of appeals within a certain amount of time, and then we have to all move on because there are continually crimes being committed, and these resources are all from the same pools? Same with the defense, by the way. The defense counsel are also pretty much the same pool.
Right. And if you want to think of it that way, there are other defendants who need their time in court. And there's only so many hours in the day, and there's only so many judges. And as I said, if you don't provide more resources, that's how it's going to have to be. And there will be some injustices there. It's going to happen. But that's the price you pay when you are trying your very best to process as many cases as possible. I know you guys are going to have lots of other questions about this stuff. I hope you'll let us know. We're always happy to answer them. We enjoy doing these episodes. We enjoy doing these explanations of how the system works, because we want you to know as you're watching it. We don't want you to be surprised or confused about what's happening in the cases that matter to you. So please shoot us an email, prosecutorspod@gmail.com. Reach out on Twitter @prosecutorspod, or Facebook or Instagram, TikTok, all that jazz. We'd love to hear from you. I will note the very best way to suggest a case or suggest a topic is email. So much better than DMs or anything else. Remember, if we're not friends with you and you DM us, half the time we don't see it because it goes into some like mystery box somewhere. So send an email. That is the best way to suggest all this stuff. prosecutorspod@gmail.com.
And one other thing I'll note, trials may be hard to follow, or cases at the trial level may be hard to follow because maybe the arguments are not televised, the trial's not televised, or you don't have time to watch a 6-week trial. Completely understandable. The appellate process is very accessible to everyone because essentially it is going to be 3 briefs, maybe an oral argument. It's going to be the opening brief that appeals the issue, the response by the government, and then the reply. And if there is an oral argument, it's going to be about an hour. It's not going to be weeks long. It might be at most a couple of hours, but there are time limits for oral argument, and they typically sit around the 20 to 30 minute mark for each side. That's it. That's a very small universe of documents that you would need to read to know what's going on. And I say that because we always encourage you guys to read those appeals, to read the primary documents. Don't take our word for it. We're always happy to explain what's happening and give you what's happening through the lens of our experience. But know that the appellate process is actually incredibly accessible to all of you. And I encourage you to read it, especially the opinions. The opinions, remember, are supposed to be written to be understood by the lay person. That may not always be the case, but you do not need a law degree to read legal opinions. They are supposed to be for the people. So with that, you can go get yourself kind of an appellate legal education just by reading publicly available documents and not just taking some podcaster's word for it or some YouTubers or CNN's headline or something like that. Sometimes they get it wrong because they're not lawyers. You go read it and you have questions, let us know. But with all that said, Brett, is there anything else you'd like to add about the appellate process?
Not about the appellate process. Do you have time for a question or do you need to go?
Let's do questions.
You sure?
No, let's do questions.
Okay.
Yes. I mean, I don't know. I can't hear anyone crying right now.
Okay. This is from 420 Flyer.
Nice.
And they want to know, why the heck is it legal for offenders to recant statements? I can understand a victim recanting in fear of their abuser or rapist, but seriously, why can someone like Larry Hall recant his confessions time and time again?
First Amendment, man. You can say whatever you want.
You can do whatever you want to do.
You can do whatever you can say whatever you want to do. You can call, someone's mommy a hairy monkey.
Yeah.
Sorry, I'm only chuckling because you said, why is it legal? You can do whatever you want.
Do whatever you want.
It's a free country.
That doesn't actually mean anything. Once you say it, once you confess, it's been said.
That bell has been rung.
Yes, and you cannot unring it. And look at we've been talking about Richard Allen. Richard Allen confessed 60-something times. And by the way, I just want to make one note on this. Every time you confess, that's a confession. There's this weird thing out there that once you confess, if you say it 60 more times, it's still one confession.
It's the same. They're individual confessions.
Those are 60
If only that
times.
applied to me eating candies. If I have one Hershey Kiss,
Exactly.
100 Hershey Kisses all count as one. No, each individual Hershey Kiss that I eat is its own caloric intake.
I mean, usually if you say something one time and then 100 times you say, I did not mean that. I was drunk. I was high. I was out of my mind. That's a little bit more effective than I said it 60 times, but it's really only one confession because I was only confessing to one crime. So don't hold those other 60 against me. It's just the one. And
here's the thing. It's fine for you to recant your confession. It's not like once you confess, the prosecution's over, right? You can confess. It still has to go through the process. If you've confessed, that's pretty good evidence against you. And it's going to be an uphill battle if you go to trial. So typically you plea out, but it's not like once you confess, game over, case can be dismissed. You're just going to be in jail forever. No, you still have to go through the conviction process because remember, the burden is still on the prosecution to meet its burden, to bring the prosecution for a conviction. And then there's still sentencing. So we don't just say, if you walk outside and say, I did it, you don't just end up in jail. There's still an entire process. And because of that, you can always recant because there's no triggering effect. It's just words that you say. It's adding to the investigation. That's bad evidence for you. If you recant, now we're going into the land of your credibility, just like all the witnesses we've talked about. Witnesses change or quote unquote recant what they say all the time. And that's allowed because what you're supposed to do is tell the truth. And if the truth is a little different than what you said before, you certainly can change it, especially if you're under oath. But there's nothing illegal about recanting. But I will say, once you've recanted, confessed, recanted, whatever, it's not good for your case.
And look, I mean, there may be legitimate reasons why you'd recant. I mean, if you're saying, well, yeah, I said it because they were beating me, they were shoving knives underneath my fingernails or something, or they interrogated me for 3 days straight without water or whatever, or I was out of my mind. I mean, the Richard Allen thing was basically he'd been held in solitary for so long that he was out of his mind. He was confessing. Problem for him was he had all these details he shouldn't know. Being held in solitary does not make you omniscient, does not make you know things you shouldn't know. And his other problem was he started confessing basically the moment he walked into jail. But nevertheless, you can make these arguments about why your confession shouldn't count. And look, there are other recantations as well. As Alice was saying, witnesses will often recant years later. either because they actually didn't tell the truth, or they now feel bad about it, or they want to help the guy out.
They know more about the situation.
Yeah.
They're like, well, actually, there's no way I could have seen that from my window. You're right, because those trees were still in the way at the time, because that was 20 years ago. And, it's now been deforested, but back then there was a whole forest. I couldn't have seen that murder happen.
Yeah.
So that happens.
And those get very little weight in court unless you have a really good reason, like Alice just said. I mean, typically recanting, and you see this a lot, right? I mean, every single innocence case is going to have someone recanting. And does that matter, and should it matter? And some people, it's just funny because, Richard Allen can confess 60-something times. We're not going to believe that. But if he recants one time, that's the God's honest truth. And you see the same thing with witnesses. Well, when they were on the stand, how could you trust anything that person said? They're such a liar. Oh, wait, they've recanted? Oh, wow. Well, what an upstanding citizen. We should definitely believe him now. It's like everything else. You have to weigh it against the evidence, against why they may have recanted. You just have to think about that kind of stuff. So it's a great question, but yeah.
Very
Alice
good question.
is right. Simple answer, First Amendment.
I probably have to cut off at
That's
one
fine.
question because apparently baby boy's mad that I'm not close by.
That's fine.
Well, that was a great question. Thank you for asking it. You guys know that if you leave a 5-star review, you can send us a question. You can ask as many questions as you want, really, as we've seen. We're happy to answer them. Thanks for checking us out here on Legal Briefs, and remember our other podcast, The Prosecutors. And until next time, Brett, I'm Alice.
And I'm Brett.
And this is The Prosecutors Legal Briefs.
Okay, it does work.
La
Great.
la la la. Okay. But yeah, it's supposed to rain here. We are closing for rain. That's what we're closing for.
You're right. It isn't actually going to get down to 32.
No, it's going to be 34 degrees, not
That's funny.
32. Those of us who know a little bit of science, that's not going to be snow, but we have closed in advance.
It'll be colder
for
on
wet
Saturday,
weather.
as a matter of fact.
I know.
Yeah.
Anyways, so one school is closed, one school is not. It's going to be fun tomorrow.
Well, maybe they'll get it wrong and we'll wake up to a foot of snow outside. That's my dream.